How does the FMCSA 14-hour on-duty window under 49 CFR Section 395.3 affect Massachusetts truck accident liability? When a massive commercial truck crashes on a Massachusetts highway, the question of whether the driver had been on the clock too long can be the most critical factor in determining who is responsible. Under federal law, specifically 49 CFR Section 395.3, a property-carrying commercial truck driver cannot operate a vehicle after the 14th consecutive hour following the start of their shift. The clock begins running the moment a driver comes on duty after 10 consecutive hours off, and it does not stop for traffic, weather, loading delays, or paperwork. This continuous window covers everything a driver does on the job, not just time behind the wheel, meaning hours spent at a loading dock or completing inspections all count against the limit. A separate but related rule, the 11-hour driving limit, caps the actual time spent operating the truck, and a driver can violate either rule without necessarily violating the other. Breaking the 14-hour rule does not automatically make a trucking company liable for a crash, but it is powerful evidence that a federal safety regulation was violated. In Massachusetts courts, that violation can support a fatigue-based liability argument when the evidence connects the regulatory breach to how the collision actually occurred. Fatigue-related crashes often share telltale signs, including a truck drifting from its lane, rear-ending stopped traffic, or failing to brake in time for a hazard ahead. Electronic logging device data, compared against dispatch records, GPS data, and fuel receipts, can reveal whether a driver exceeded permitted hours before a crash took place. Trucking companies sometimes pressure drivers to push beyond legal limits through tight delivery schedules, pay-per-mile compensation structures, and aggressive dispatch instructions. Federal regulations prohibit motor carriers from coercing drivers to violate hours of service rules, meaning a carrier's own policies and practices can become central evidence in a liability case. Attorney Dino, the 1000th. Colucci has represented injured clients in Massachusetts truck accident cases since 1988, securing results that include a $2.5 million wrongful death recovery against a worldwide trucking company. Managing partner Darin Colucci has helped obtain a $6 million wrongful death settlement and served as lead negotiator in litigation that produced a $70 million settlement for more than 100 plaintiffs. The law firm investigates whether violations of FMCSA hours of service rules contributed to a crash and works quickly to preserve critical evidence, including electronic logs, before it disappears. If you were injured in a Massachusetts truck accident, contact Colucci and Marcus, PC at 617-698-6000, located at 424 Adam Street, #101, Milton, Massachusetts 02186, United States, to schedule your free consultation today.